Shetty's bill, and then Crosby, and then Attar, and then Hill. Just let me know when we're live.
Live.
Good afternoon. This is a meeting of the House Criminal Law Subcommittee. We have 4 bills on tap for today. House Bill 33 from Delegate Shetty, House Bill 34 from Delegate Crosby.
With them.
Okay, thank you. Delegate, thanks. You get to, please mute yourselves. House Bill 211 from Delegate Attar, and lastly, House Bill 437 from Delegate Hill. We're gonna go ahead and get started with Delegate Shetty's bill. So if you want to go ahead and bring her into the room along with any of her informational witnesses, we can get started on this. Colleagues, House Bill 33 was the bill to conform Maryland's drug schedule to the federal drug schedule. And the bill, I think, doesn't have amendments. And so I'm hoping—
Move favorable.
Does anyone have any discussion on this bill? Any lingering questions, or are we good to try and move this one?
So just, if I could, Mr. Vice Chair, so, yeah, give us a brief synopsis. What exactly is this doing with the CDS schedules?
So the feds change their schedule when needed, but since the Maryland legislature only meets, 90 days per year, we conform when we get around to it, which theoretically would be every year, but we didn't do it, I think, the last year or so. So we're 2 years off schedule. And if you look in your testimony packet, an example was given from the Epilepsy Foundation about a drug that had been descheduled and made more widely available, but Maryland's schedule had not caught up to that 2020 change. So the request is to just have us conform to the federal schedule without having to do this every year.
But on the federal schedule, marijuana is still illegal, right? How does that?
Well, that's true now, and in the future. So our current moves are beginning to have that conflict, but that's true with anyone else. But I think there's been talk of the feds doing differently.
Delegate Moon, can I make a clarifying remark?
Yes.
The bill, and Delegate Shetty and the advocates can correct me if I'm wrong, but the bill is not really changing what's on the schedule. It's just what is in the statute book might be inaccurate. So the bill is just taking everything out of the statute to prevent confusion. It's not making any changes as to what would be on the schedule or not. It's just taking the listings out of the statute to prevent confusion.
I can add to that if I may, if you would like.
Yeah, please.
Thank you, and thank you, Claire. I think that's a really excellent summary of the drafting of the bill. And what the bill does is it also, as Delegate Moon noted, sort of future-proofs the bill to allow for the department to have a process in place where, without the action needed by the General Assembly to add or change things within the drug schedule to mirror the federal schedule, they would still have the authority to do all that they need to do, and we just don't have to pass an annual bill that typically we get from MDH, but they're busy with COVID and other things happening, and so we haven't gotten to it in a bit. So this is really just about sort of cleaning up our code, enabling MDH to still have discretion while at the same time removing a legislative requirement for us going forward.
And we have Pam Casemeyer from representing one of the pharmaceuticals to provide some clarity also, if you want to.
Yeah, and thank you. I don't know that I have much to add. Just wanted to reinforce one thing. Maryland law, as this said, this is sort of a cleanup because generally speaking, we follow what Maryland law does, and then we get these unintended confusions when the feds act in the middle of the year and we can't fix it till later. But Maryland also has provisions that allow you to object to what the feds do or to add something yourself. All that stays in the law. So none of the current authority that Maryland has to take its own action separate from the federal government is removed from current law. The only thing that's really removed is all the list of the specific drugs that are in the federal law. So that was just the only other thing. We aren't lowering Maryland's authority to do its own thing when it wants to.
All right. Any other questions on this one?
Move favorable.
Second.
Okay, let's just do this one by voice. All in favor of a favorable on House Bill 33, say aye.
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 Does anyone want to be recorded in the negative on this? Okay, so thank you very much, Delegate Shetty and friends. Next, let's move on to House Bill 34. This is Delegate Crosby's bill. Do we have Delegate Crosby?
No, not today.
Can you read the bill number again?
House Bill 34. This one is this is about indecent exposure within sight of a minor, and the bill would move the penalty from the regular exposure being up to $3,000 and $1,000 to the bill would move it to $5,000 and $10,000. By way of history, I think we had this in subcommittee 2 years ago, and I think this one was in that year we got cut short by the pandemic, and I can't recall exactly what the subcommittee did. We had some discussion about this. I think we may had been heading in the direction of moving it, but we never sort of finished the conversation that year. So so that's the bill. MCASA is also here. They had an amendment suggestion that the extra penalty should come with a requirement that there's at least a 4-year age gap to address some of the concerns about this. Delegate Fisher, is your hand up to discuss this one? Yeah, well, let's talk about it. How do folks feel about this one?
Well, there's definitely a sponsor problem. No, I'm just joking. I just wanted to clarify there's not. He's my favorite sponsor. I just had a clarification about, and maybe this is for any of the advocates, or I don't know if this is for Claire. It does add that you may not commit the common law crime of indecent exposure within the sight of a minor who is at least 2 years old. So I guess my only clarification point is like, and it is a little strange because I'm not a mother, or I'm not around young kids under 2, so I would lean on Sandy and Delegate Erican and Deborah. But I think I think it's 2, right? Because it's like people change in front of their baby and are running around with, young kids. And so I guess my question is the 2-year-old thing, but I totally get like an under 2 kid is just, with their parent, and indecent exposure would be like someone not related to the child, or also could technically a parent be charged with indecent exposure with a child. I'm a little confused with that. You get what I'm saying?
Lisa Jordan, do you have an answer on this parent and young kids?
Perhaps. Thank you, Mr. Vice Chair and members of the committee. I appreciate your question. The 2 years old actually came from our favorite sponsor, Delegate Crosby, and I think he was concerned about exactly the sorts of things that you're thinking of. That was also MCASA's concern about requiring that 4-year age gap. And just considering all of that, I also just wanted to suggest that perhaps the committee would want to say a person may not commit the common law crime of indecent exposure and add with prurient intent within the sight of a minor. I don't, perhaps I'm projecting, but I don't think that people are as concerned about someone relieving themselves in front of a child. We're concerned about somebody who is actively trying to, gain sexual satisfaction by exposing themselves to a child. And so if you added after indecent exposure, with prurient intent, I believe that would address that question, and that would take care of the parents, that would take care of the sister, that would take care of, these people who maybe they're not being modest, but they're not criminals.
Yeah, I'd rather be safe than sorry if we could add that amendment. I'm not going to talk about my mother on a subcommittee live call, but yeah, everyone has different rearing, and so I just wanted to clarify that. So if I could move that amendment after people's questions, Mr. Chair.
Second.
Could I also add something, Delegate?
Sure.
The indecent common law crime of indecent exposure is the willful and intentional exposure of the private parts of one's body in a public place in the presence of an assembly.
Right.
So that would kind of rule out the family, within your family home situation.
Thank you, Claire.
Delegate Davis, Eric Ann Shoemaker. Let's just keep the convo going.
Thank you, Mr. Chair. I agree that we should have more guardrails, even with the definition of indecent exposure. That was my first question, but I like the guardrail with prurient intent because I can see college kids streaking down the campus, and there'd be a kid there, or other things. But I really think we need some more guardrails on this.
Yeah, I'm with the prurient intent. I'm glad that the definition is better, but I'd like to add that extra piece in there because we don't want to criminalize normal behavior. I mean, is it public if you're like, I don't know, my toddler and my 8-year-old are outside and my 8-year-old decides to pee outside? You know what I mean? Like it's technically public, you know what I mean? So if we just add prurient intent, I think that really secures it a lot more. I'd love to see that added.
If I could really quickly, what about breastfeeding?
I think breastfeeding is protected in Maryland. I know because I pull my boobs out all the time when I breastfeed my babies. So, and I've done it all over the world, even in places where it was illegal. And you know what? No one has said anything to me, which was smart for them.
Delegate Shoemaker.
That's kind of a hard act to follow, but anyway, Pippi had a bill before us, HB 471, that had the same type of theme as this particular bill, and his was entitled Criminal Law Indecent Exposure with Lascivious or Prurient Intent. So, just to make, allay some folks' concerns. I mean, we use that type of language in Delegate Crosby's bill. I think that would be swell, even though there is a common law definition, which should also satisfy folks. So, for what that's worth.
All right. Well, before we try to move on this prurient intent thing, how do folks feel on the other suggested amendment on the 4-year age gap?
I'm sorry, Mr. Chair, can you clarify?
You know what, Janine, can we put that one up on the screen? Since that one came in, we have language to look at on that.
Who's that amendment from? The sponsor? Or who's that?
It's MCASA. It was in the testimony that was submitted at the bill hearing.
So, Mr. Vice Chair, may I just add that the sponsor also agreed to this language, and I think he may have even sent in an amendment, but it does feel like a very long time ago. That was a January hearing.
Got it.
The sponsor, just to add information, suggested the 4-year age difference because that's the age gap that's commonly used in the sex crime statutes.
And so the idea is that you don't want to get people dating or something like that in trouble?
It wasn't even just dating. It was also just, kind of people messing around. That this was not designed to punish teenagers who were engaging in play, but again, not prurient intent, just say, okay, we're only going to apply this to people who are more than 4 years older than the child.
Delegate Anderson and then Davis.
Can you hear me?
Yes.
I'm sorry. Okay. I am in agreement with the idea of adding prurient intent, which to me indicates that the person who is doing this probably has some kind of mental health problem. So therefore, there ought to be concomitant with that the ability for the court to try to address that problem with more than just punishment. Because the first time this person is convicted of something like this, he'll probably get probation. Maybe the second or third time he might get 6 months in jail. But the point is, on any of these occasions, he's not getting or she's not getting anything to help her or him with the problem. No counseling, no mental health treatment, things like that. So rather than just have this knee-jerk reaction where we just add more time to the penalty, make it a greater punishment, why don't we consider something that would also help solve the person's problem so they don't come back into the criminal justice system again in the first place?
Delegate Davis.
I 1000% agree with Delegate Anderson. We learn in judiciary that penalties without help just creates more places in jail. So I 100% agree, and I don't like the idea of upping the penalty, and I agree that we should add something, some counseling or something to the bill. Also, I wanted to make it clear that this does not affect two children, right? I mean, could it be a 4-year and a 6-year-old? I mean, wait, a 2-year-old and a 6-year-old?
It couldn't, because kids under isn't it 7, Claire, don't get charged with stuff.
Well, I mean, conceivably a teenager, or I don't think there's a clear rule on the age below which a child can't be charged with a crime, but conceivably under this statute, a 13-year-old could get charged with it, but they would go into juvenile court. I mean, you could change it to an adult may not do this if you wanted.
Wow, seems like there's a lot to do to this bill.
Well,
I just want to keep getting the temperature on these changes. Adult, prurient intent, 4-year age gap.
Well, I'm not really comfortable with adult, because I think like there are teens that are kind of all over the place. And I think more young children, in my opinion, is very anecdotal, are more likely to face, I think, sexual assault or harassment children are more likely to face that with teen situations than anything else. And this is what I always say with these bills, and whether it's, I understand the codification of like mental health help, but I don't know if we do that with crimes. like putting a minimum requirement on mental health. I don't know if we can, Claire, like a program, but what I am saying is that's why we have prosecutorial discretion. So it's like, I think, I don't know. That's just I'm not good with the adult. I'll leave that to the prosecutors for each case to figure out with the kid. And if it is a kid, it is juvenile already. I do think you can lower the incarceration or the fine, of course. I would agree with that, but I don't think, we could go through every crime in the book and be like, this shouldn't be for a kid. And so, I mean, that's why we have to just, I don't know.
All right, Delegate Eric Hand.
Yeah, I would just second what Delegate Fisher just said. The cases that I know of all involved minors. Minors were the perpetrators. So, that's the hardest part about it. And I mean, of course, usually those kids were exposed to something or were abused themselves, but their victims still need some kind of protections. I think prurient does help though, because if a teen is just like being stupid and that's their intent is not sexual in nature, then, which is like the majority of stupid things that kids do is not, sexual in nature. So I think those kids are protected, but the ones who are actually hurting people and doing so, intentionally. And I think the judge, can order, right, mental health services. He could say like, this child needs to, receive services for, this. And I mean, I have a couple of cases I'm very familiar with personally, were the mothers of the perpetrators I know quite well. And they did receive services. There's definitely work that we can do on the services. I mean, one of the mothers spoke to me about her child who was molesting younger siblings, and she was pretty disturbed by some of the quality of therapy. She felt like they were almost trying to make excuses for her son's behavior. So he would come home and be like, well, I couldn't really control it. And she actually sat in on some of it and was really disturbed by some of the stuff. And she ended up, I think, pulling him out of that and getting him into some other therapy because she was not pleased with the outcome. And unfortunately, ultimately, the child had to be removed from the home and had to go under guardianship of another family member because it just was not safe for her young children. So we definitely have room to improve. It's just such a difficult topic. So prurient, I think, helps a lot. And I'm fine with the 4-year one as well. I think that helps, definitely helps, because most of the little kids don't even know what they're doing. They're definitely not sexual in nature.
Delegate Anderson. You're on mute.
I just want to suggest that we place this bill on hold. I'd like to craft an amendment to allow a judge or to suggest to a judge that mental health treatment might be an alternative sentence to incarceration. I mean, this is not the kind of person you want put in the general population. A guy who exposed himself to a child, and you put him in jail. I'm not sure that's what, as policymakers, we want to do, especially when there's other means available. I think, just like with people who are hooked on drugs, where a court can sentence a person to the Department of Health and Mental Hygiene for drug treatment. I think if a person has this mental health problem, that the same alternatives should be available. So I'd put it on hold. I'll contact Bill Drafting to try to get the appropriate language to be ready for the next time we meet.
So let me just say, when we've done that kind of thing in the past, it's always been a may language, just as it were with the judges. The judge may refer. I'm not sure, and maybe this is something Lisa Jordan.
I'm okay with May. May is fine.
Do we know that there's an existing place that they would refer folks to?
Don't we have an expert here?
Yeah. does one of our expert friends know if there's a place that a judge would refer someone to?
Mr. Vice Chair, members, there are some very limited resources. There are extremely few resources available for treatment of sex offenders. With all respect to Delegate Anderson, who I agree with on many things, I do wonder if this amendment is needed and why it would be particularly applicable to indecent exposure to a child and not to all other sex crimes. And my belief, and perhaps Ms. Rossmark could comment on this, is that the courts already have the ability to refer people. Parole and probation already has the ability to put folks into treatment when needed. So I'm not sure what's special about this particular issue that would need an amendment that would permit that. I think it's already permitted.
Well, no, the bill came in as an enhanced penalty for individuals who do it in front of children. From 3 to 5 years, I think, was the enhancement of the penalty. And I'm always been of the opinion, before we enhance penalties, can't we find alternative means of dealing with situations rather than just have a knee-jerk reaction? Oh yeah, that's a terrible thing to do. Let's put them in jail for 5 years. And I'm just thinking that, and I agree with you, these kind of resources should be available for all of these sex type crimes, but it just came up today for the reason that we're talking about an enhanced penalty.
Yeah, let's put a pin on this. I think those are both good points, actually. Kurt, or excuse me, Delegate Anderson, you raised a good point, but I also think it's a good point that we haven't solved or addressed that gap in the rest of the code. But let's just put a pin in that, and I think we are going to have to move on and just put this on hold for a second. Delegate Erican, do you have a final thought you were trying to get out on this?
Yeah, I would just say that I would definitely not want, we need to separate out if it's a minor offender, I think. I mean, this behavior is the precursor to raping people. So it's like a scale. I mean, you start out doing small things like this, and then as you get away with it, that behavior tends to escalate. That's how it works. So, certainly young people are more receptive to behavioral modification through therapy and treatment. Older people are a lot less receptive to it. And so I think if we go forward with that kind of amendment, something that says for minors, the judge may consider alternatives to incarceration. That's, I think, obvious. I think most judges would not incarcerate a child. None of the children I know have ever been incarcerated for this kind of behavior, and they did way worse things. So, but for adults, a judge can require mental health stuff, but adults that are escalating their sexual predation of children, I don't even think that piece needs to be included. It makes us, I think it's not a good look.
Well, let me ask this before we move on. I just want to get a gut check here. If we put on some prurient intent thing and stick the 4-year gap on there, are there folks who still feel they want to oppose the bill?
We got to lower the penalty too, to keep the penalty to what it was.
That was the purpose of the bill, though, right?
Yeah, I mean, we'd have to lower it to 4 years or something instead of 5, I think, or lower the fine amount or something like that.
Mr. Vice Chair, may I just provide one other piece of information?
Yes, please.
Thank you. So my understanding from Delegate Crosby is that this responded in particular to a case in St. Mary's County, and the reason for the penalty increase was not so much to increase incarceration, but it was because it affected the security clearance for someone there. And because it was a lower penalty, it was not affecting his security clearance. They needed it to be a higher penalty because they did need to have it kind of flagged for that process. So I just offer that because I fully appreciate and agree with the desire not to simply increase penalties, and there are definitely reforms needed for the criminal justice system. But this really is more of that ancillary issue of how it intersected with security clearance.
So someone was charged with this and then they did not lose their security clearance?
I can let me double check on the facts, but that's my recollection of what prompted the bill.
Ooh, thanks.
Well, let me ask this then. Delegate Anderson, how are you feeling on your amendment desire?
Yeah, I was going to press it. I just think that,
That's
look,
fine. That's fine. If you're going to press it, then I think we have to hold this for a second. Okay. Thank you. So moving past.
My only other thing, Mr. Chair,
Yep.
I'm so sorry. Delegate Anderson, when you go to get the amendment from the amendment office, I do think we have to have some sort of synergy. I think like any sexual crime to minors then should have a mental health, whatever the language you're gonna do. Like if you're not gonna leave it to whatever local jurisdiction to figure it out, then like if we do pass it with the amendment, I think anyone that's doing, do you know what I mean? Like then I think you have to kind of have it whole, I think.
Yeah, this just does not make sense to me.
I think
Well,
we're going,
let's-
I think we're going
let's-
too far.
Let's
Yeah,
we can
it's
have
going
this
pretty far.
conversation offline at this point. Okay, we're gonna move on. So House Bill 211 next. If we can bring those folks in, this is a bill from Delegate Attar. The bill came in, and I believe it's about straw purchases of firearms, and essentially to minors or other prohibited persons. And the bill originally came in to up the penalty from a misdemeanor to a felony, I believe. But there is now a strike the bill type of amendment, which we can put on the screen, I believe. And the amendment would alter the bill so that it would no longer felonize the straw purchase. It would instead add the straw purchase offense to Criminal Procedure 2203, which is a section of code that allows an officer to make an arrest without a warrant, but with probable cause. And so there's a list of offenses, concealed gun crimes, and some other offenses, but this would add straw purchase to that list. And I gather the intention is to facilitate enforcement of these straw purchase offenses, but we do have Delegate Attar here if she wants to explain what this amendment is proposing to do.
Thank you, Mr. Chair. So the intent of the bill is right now, straw purchases are misdemeanors. So you can have a 30-year-old who is not prohibited from having a gun, purchases guns, and is selling them to minors or prohibited people. Since it's a misdemeanor, officers right now cannot arrest unless they actually see that 30-year-old selling it to the minor. And if they can't arrest right then, they would have to go get a warrant for their arrest and conduct some investigation after that. And then state's attorney's offices also, these will be handled in district court as misdemeanors, and the investigation process is very different. So that was the intent of the bill, to change it to a felony. So officers would be investigating more often, state's attorney's offices would handle them differently, and they would be handled in circuit court. My understanding was, and I understand that people don't want to change things to felonies, and I get that 100%. So that's why instead, now an officer does not have to actually see the 30-year-old selling it to the minor or the prohibited person. But if an officer stops a 17-year-old, finds a gun on them, the officer is very likely still going to arrest the 13-year-old for possession of that gun. That has nothing to do with this bill. That 17-year-old is probably still going to be arrested. But now if the 17-year-old says, well, my 30-year-old uncle sold it to me, the officer can now say, is that your uncle? Yes, and arrest that uncle for selling the gun, if we put this amendment in and strike the bill. So that's the intent of the bill.
Delegate Arakan.
I would move favorable on the sponsor amendment.
All right, let's again do this by, well, let's pause. Are there any other questions or comments about the Delegate Bartlett?
I was trying to follow you, Delegate Attar, but I just didn't catch everything. I'm sorry. And I also pulled out I needed to pull out the code to look at it. So can you just, for a non-prosecutor, can you just explain this one more time?
Sure. So right now it's a misdemeanor, and the bill originally was not changing the penalty. It's up to 10 years, regardless if it's a misdemeanor or a felony, but the bill was changing it to a felony. And the reason for that was because, so right now a police officer, we have so many misdemeanors, and if they can't arrest right on the spot, if it's not a crime that they can arrest without it being in their view, they have to go and start doing an investigation. They have to go take out charges for a warrant and then get an arrest warrant and then go and arrest. And unfortunately, our officers throughout the state of Maryland are all overwhelmed, and we're not having officers as much as we should investigating misdemeanors. We have some crimes.
Hold on one second, Delegate Attar. Here's my question. What I'm trying to understand is, if I'm looking at, we're on House Bill 211, right?
Yes.
Okay, so it's in the Public Safety Code. So what I'm confused about is, how do we get in the Criminal Procedure Code of Section 2-203? That's the confusion part.
Got it. So I struck the bill, and what the amendment does is, in the Criminal Procedure Code right now, there are exceptions to warrantless arrests. So this is just adding straw purchases to that exception. That's why it's bringing it to the Criminal Procedure Code.
Okay, now I get it. Okay, thank you.
Sure. Thank you for the question.
Delegate Anderson.
Yeah, my concern is creating a new exception to warrantless arrest. I mean, it's well settled right now that a police officer can only arrest a person if he sees a misdemeanor being committed in his presence. And I think that's been the law forever. Situation, and look, Delegate Attar, I think that even though police officers are somewhat overwhelmed around the state, the scenario that you gave, where the 17-year-old gets arrested and says, well, my 30-year-old uncle gave me the gun, I don't think it's going to be much of an investigation. The officer can just go to a judge and get a warrant for the uncle without doing much investigation at all, right?
That's correct, but I can tell you from my experience as a prosecutor, I've seen so many times where straw purchases did occur and arrests weren't made. And if you look at the fiscal note, I believe it said last year there was one arrest in the entire state of Maryland of straw purchases. And I've seen myself it happening a lot more often than that. So this is as a way to fix that problem.
Thank you, Mr. Chair.
Delegate Davis.
Thank you, Mr. Chair. Yeah, this is a complete strike. We need a chance to take a look at it. It's not, yeah, this is our first look at it. I'd like to have an opportunity to take a look at it.
Okay, well, let's also get our questions on the table too. So if there are specific concerns, we can try and at least know what information we want to track down. I put in the chat here a link to the other crimes that are subject to warrantless arrest in Maryland. And actually, can we put that up on the screen, maybe?
Yep.
Yeah, I can't read the screen because I'm using my cell phone. Could you just go over?
Yeah, I'll once it's up on the screen, I'll just rattle a few off here. Manslaughter by vehicle or vessel, malicious burning, malicious mischief, theft under 1,000, false fire alarm, indecent exposure, CDS crimes, wear, carry, transport, concealed carry, prostitution, and violation of pretrial or post-trial release.
All right, Mr. Chairman, I apologize for breaking in like this, but now that you've read those to me, and all her bill is going to do is to add straw purchases to that list, as opposed to making it a felony, I will withdraw my my objection.
I'll also tell you, for your benefit, that your mayor is supporting supporting the bill.
What if
Delegate Davis. Delegate Davis.
Oh, no, I'm okay.
Okay. Delegate Erican.
I would just move the previous question on the favorable on the amendment.
Well, hang on there. Delegate Bartlett.
Can I just see the amendment one more time? Because
Yes.
I
Yes.
just need to. Okay, thanks. So we're getting rid of all of that, and then we're just saying, I just need to see the straw purchase language. That's all I want to see. Thank you. Okay.
Yeah, I mean, I'll admit, I thought this was an interesting move on the bill, but when I pulled out the list and read the code, and I said, oh, there's already a whole bunch of stuff
Yeah.
on this list that's less serious, in my opinion, than selling a firearm to a prohibited possessor. So,
Okay, and so under 5-141 of the public safety article, I noticed you were using minor as a the minor as an example. Does 5-141 specifically go to minors or something? Or was that just an example?
No, if I may, Mr. Chair,
yeah, please.
that was just an example. It's any prohibited person and minors are prohibited.
Okay. So that, okay. Because my code is all the way over there. And I did, every time I leave, I miss a point. So, okay. So 5-141 is just simply about selling to a prohibited person. Okay, gotcha. All right. Thank you.
Delegate Davis, your hand's back up.
I still like a chance to take a look at it in whole. I hope this isn't going to be our policy that we get like railroaded
That you get
and having to
shotgunned?
decide right away. I mean, I would like to sit down and take a look at it. I mean, it's a complete change. I applaud my colleagues for trying to piece it together, but that's not, I can't do it. I can't even do it on the screen. I need to print it on thing.
Okay. All right. Okay. We'll chuck this one onto the list for next time also. I'll, it sounds like folks are getting there on this one. So hopefully we can.
I think I can get there too, Mr. Chair. I just don't feel comfortable.
Okay. All right. Last bill. Sorry. Thank you, everybody. We'll be back to this one at our next. Next bill, House Bill 437 from Delegate Hill. This is a bill about swatting and phone jamming a 911 service. In current law, I believe you would probably be looking at 6 months for swatting and 3 years maybe for phone jamming. And the bill would make both a felony and would up the swatting from 6 months to 3 years and the phone jamming to 5 years. And part of it is that, the phone jamming really is just in this general section of code about using phone line to be a nuisance to someone else. So it's in there with kind of smaller offenses, and I guess this bill is trying to elevate the specific offense of sicking the police on someone or stopping a emergency response. So there are two amendments also that are in the discussion mix here. One is that the Senate sponsor and I believe the House sponsor has also requested this amendment, has an amendment that would, the bill right now has swatting and phone jamming in sort of two separate sections. And I believe the Senate amendment would bring them together. So Janine, if we could put the reprint on the screen with what that looks like, we can take a look at that. And I'll say, while that's going on, MSBA also requested an amendment that would not change this to a felony. It would leave it as a misdemeanor, but go ahead and accept the higher penalties on this particular type of offense. All right, so up on the screen is a reprint with what the
Whoever's
sponsors.
sharing the screen, can they zoom in? Sorry. Go.
Did you hear the request to zoom the I think it's in that bottom right. I see it.
Yes, thank you.
It says 90% or something. Yeah, there you go. Yeah, if you scroll down a little bit more, we'll get to the meat of, yep, keep going. Here we go, wait. Here we go, yep, this is it. So this is the meat of the requested bill at this point.
Okay, I see what they're doing. So the new 3 is essentially restructuring what swatting is into the, is that what it's doing?
Yeah.
It's a little weird.
Yeah, it's very specifically about trying to sick the police on someone.
Yeah, with the intent to initiate an emergency response and annoy, abuse, torment, harass, or embarrass another by knowingly providing false statements. Okay. Did the advocates weigh in on this? I mean,
I don't think there was any opposition to this bill. It was, we had the MSBA request to not felonize the offense. That was the only suggestion.
okay.
So, all right, well, let's get some discussion going. Delegate Davis.
I'm sorry, I didn't put my hand down from last time. I feel a little bit more comfortable about the swatting bill. And of course, I like the MSBA amendment.
Delegate Fisher.
Thank you, Mr. Chair. I just had a question. Thank you, Delegate Hill. I think I saw Delegate Hill on here. Thank you, Soror, for being here. I just had 2 questions. 1, I wanted an example of where this came from. And 2, maybe Claire or Holly can distinguish what's the difference between this bill and what we just passed, Delegate Jackson's bill with the false statement to an officer, 911 call, penalties, and like, do they align and are they different?
Well, I can just say briefly that the false statement bill that we had on the floor today required race or some protected status being a substantial motivating factor to get you to the 3 years that's in that bill. This is a little higher. This is up at 5 years, but it doesn't require race, gender, et cetera, to be a substantial factor.
Right. And that one, the one we just passed to this morning, was that, I just don't have it in front of me. That's a misdemeanor, which is it?
I believe that's a misdemeanor, but that one was, I think it's 3 years we did on that one.
Okay. And then this one would have the same synergy with the amendment. It'd also be a misdemeanor.
Yeah, I mean, the underlying offense, the false call to an officer or false call to the police generally, I think, is up to 6 months. And so that bill said, and if you were motivated by race, it's up to 3 years. And this one is saying it's not just a false call to the police. You're trying to get a SWAT team or whatever sent to someone's
Right.
house, then it's this higher penalty than just the 6 months currently on the books. That's just applies to anyone calling the police with a false statement.
Gotcha.
Delegate
Thank you, Mr. Chair. I was just trying to wrap my head around the concepts.
So ostensibly, all of them could be stacked, right? If it was racially motivated and they access this public safety point to do it, you could stack the charges.
I
Right.
think on a hate crime charge, you get that in addition, but
This would be the charge, and then they would say additionally, it's a hate crime because they committed this crime, they're looking at up to 5 years. And we find out that that's racially motivated, or protected class motivated. And so then it's another potentially 3 years on the 5 years.
Don't quote me on that. Does council, if council or someone can pipe in on that, but let's put a pin on that. I have to pull the Jackson bill, but I think that sentence is separate.
Yeah, that's the intention of, one of the intentions of the hate crimes laws. That it be double.
But again, this bill doesn't require any of that race motivation to be proved. It's just generally if you're trying to SWAT someone.
What was the
So-
vote on the Senate side? Do we know?
I don't know that they voted on this yet.
So this has the Senate amendment. Is that what we're looking at now, the Senate amendment?
This is what I believe the Senate sponsor is requesting. I don't know. I'm not sure that they've adopted this yet.
Okay.
Delegate Anderson.
Yeah. Wait a minute, I'm off. One question. Does anybody understand what it means to try to initiate an emergency response? Does it mean to send an ambulance because that's an emergency? Or does it simply mean to send a police officer? Or does it mean to send, as you've been talking about, the SWAT team? That language right there, how do you interpret that? How would a state's attorney prove that the person intended to initiate an emergency response?
Well, wouldn't it go under the definition, because we've got the answering point defined, right? And we've got the public safety agency defined. So, I mean, is it too far of a jump to infer that the emergency response is as a result of the answering point and the public safety? Is that too much of a jump, Delegate Anderson?
Well, what is the emergency? I mean, give me an example. Like, okay, from the bill we had the other day with the hate crime involvement, a white woman called and said there's a black man outside and he's whatever he's doing. Okay, the police respond. Are they responding because it's an emergency, or is it because it's a call? Or does she say, "Oh, this guy's got an AK-47. It looks like he's going to shoot up the place"? Blah blah blah. Is that what we're talking about?
What you just said is the classic swatting example.
Yeah.
You say there's a madman here with a bunch of guns. You better get here right quick, and then they send some serious folks in.
Well, wouldn't they send? I mean, I don't think that.
I think that it's what they're intending. I mean, I'll give you an example. There was a I don't know. Don't ask me why I know about some of these cases, but there was a gentleman who swatted some folks, had some penalty for that, and did it again later. And they were clearly intending to, so there are repeat swatters, believe it or not, folks who resort to this sort of thing as a means of whatever, going after political. I mean, that's another one, like political folks that you disagree with.
Okay,
So
but
there's
my
definitely
question,
behavior.
my question is, did we have any testimony from the police that says a person making a phone call could actually invoke the police themselves bringing the SWAT team, or is the decision to bring the SWAT team made by the police after an assessment of the situation? Because the SWAT team just ain't sitting around waiting.
Delegate Hill, the sponsor, has her hand up, so perhaps wants to pipe in with some insight onto some of this.
Thank you, Mr. Chairman,
Okay.
and thank you, Delegate Anderson. So you can take, for instance, Wolf Blitzer, right? So somebody called the police, reported his address, and reported a very dangerous situation, and the SWAT team showed up at the house. They don't investigate first. If you say that there's a hostage situation and there have been gunshots fired, okay, they're going to show up. And in other states, people, the concern is that people can get killed in that situation, because we know that sometimes the police are just going to go in and they're going to lean on the report that they got from the PSAP professional. And when you send these law enforcement forces out under false pretense, it's also at risk for the general public, because they're speeding along to get to this situation. And, so it does happen. And I thought that on number 3, which the amendment would add to a public safety or PSAP with the intent to initiate an emergency response, there's an and there, not an or. And so you're trying to get an emergency response, but usually it's SWAT, but it could be police generally, it could be an ambulance, and to annoy, abuse, torment, harass, or embarrass another, and you knowingly know that what you told them was going on was not going on. That's the point, is you knew you were lying, and you only lied. So we're trying to make that distinction between, the kid who thinks that this is funny stuff. We're going to make some fake phone calls and see what kind of response we can get, right? Or the drunk who's making a fake phone call to see what kind of response. But we are trying to capture the people who abuse emergency personnel to get back vindictively at an ex or someone they're angry with, or a neighbor who's playing the music too loud or whatever. We want people to understand this is playing with serious stuff, and there are serious consequences to doing it. I don't know if that helps.
Yeah, and I guess my underlying question remains: did
Just
we
call
ever
it.
hear from?
Hello.
Did we ever hear? Hello.
Yeah.
Go ahead.
Can I speak or? Okay. Did
Mr.
we ever
Chair?
get any testimony?
Hold on, I got to turn my volume back up. Are you there, Mr. Chair? I wanted to ask a question.
Oh, hold on. You're talking on top of Delegate Anderson. He's still
Okay,
going.
sorry about that.
Yep.
Yeah. Again, I may have missed the hearing on this, but I was trying to find out if there was any testimony from police agencies with regard to the actual A, how often does this happen? B, what is the administrative way or the police way of assigning a SWAT team to a situation? Is it based upon what the 911 operator says, or do they send an assessment team before they send the SWAT? Because the SWAT team just isn't sitting around waiting to be called. They have to be assembled and then sent.
Right.
So
the testimony was that yes, this happens, and it happens with some frequency that they do not want the public to be aware of, that they tend not to advertise it because they don't want copycats. They did not testify as to whether the response is the tactical unit, the SWAT team, two officers with a dog. They didn't testify as to who responds, because I think it depends on, but they are responding to the report as it's given to them.
Okay, which agency was this?
This came from the all of the emergency person. I'd have to look at the witness list to recall, but this came from the.
I can tell
task
you from
force,
the
yeah.
witness list who was, it was the Maryland Department of Emergency Management, the Howard County, Harford County, Director of Emergency Services, Montgomery County, Director of 911, MACO, and MSBA. All supported.
By letter, or they were actually testified in favor of it? I'm just curious.
I don't recall who showed up. Maybe
Okay.
Delegate Hill can recall now. Okay. All right, Delegate Bartlett.
Thank you, Mr. Chair. So I was on the phone with Dorothy Lennox from the DV community. I had a bill that essentially had a similar issue. The issue was the same, but yours goes much farther, Delegate Hill. So thank you for bringing this bill. But the DV community did put in an amendment last year, and they put in, and they'd like to request an amendment this year. They did not come to you, Delegate Hill. They said it must have been an oversight. But I can share that amendment with you. And it literally just carved out it carves out anyone, it makes an exception. Not because it's good to call and to summon and things of that sort, but I think the purpose was that they didn't want it to apply to someone who is requesting help, and then their abuser come back and say, you only did this because, you know, you were trying to get at me. So there is actual language. It's really easy language that I can give you. It's really easy. It just says this section does not apply to a person who requests help from a police officer in accordance with 4-502 of the family law article. So if you wouldn't mind accepting that as a friendly amendment, I can get it to you. And they just said they overlooked it. They just didn't catch it.
Yeah, if they could send that to me and also to Senator Kagan so we can try and move.
Okay,
jointly.
thank you.
All right, thank you.
Delegate Fisher.
I was just gonna ask if we could move the current amendment favorable onto the bill, or
Hang on, Delegate Erican.
Yeah, I second that. And then maybe we hold it until we get the advocacy's response and see if there's any tweaks we need to add, you know, at that point.
Well, okay, hold on. So if we take the sponsor amendment, we're basically agreeing to go forward with enhanced penalties on the swatting and disruption of the 911 center, to be clear. So let's do this again by voice vote. Can we adopt the sponsor amendment that we just saw?
Yes.
So everyone
Yes.
say yes if you're in favor of
Yes.
this. Does
Yes.
anyone want to be recorded in opposition to adopting that amendment? Okay. I want to take up the MSBA amendment next, which would leave this as a misdemeanor instead of a felony. How do folks feel on this one?
Can you repeat that again?
The MSBA request was to leave this as a misdemeanor and not a felony.
How does the sponsor feel?
So the discussion in the commission had to do with not just the penalties, but it being a serious enough offense that the prosecutors would pursue it. And you all have a lot more expertise than I do as to what that means. You also have a different sense of where we as a state are trying to put, the felony misdemeanor issue. The sense was the group felt, the people who are living this stuff felt that this should be treated as very serious, because it's not just a matter of you're wasting financial resources, but you are actually putting people at risk of losing their lives. And that could be anyone from, as I said, the target of the swatting to the emergency personnel, first responders who are responding. We see lots of examples of folks coming in and being, shot at, and also people going in and shooting at people, as well as the innocent folks along the way or in the neighboring apartment or whatever. That this is not just a mischievous thing, and not to say that the penalties on a misdemeanor aren't significant, but that's the feeling, and it really is up to you all to put it in the full context of what criminal law looks like in Maryland and what we want it to look like. So I think that there's no question is the recommendation was strong that it should be a felony because of all that comes with that. But we want it to pass, and if becoming a misdemeanor is what's going to serve the greater good, then we would have to accept that, or it would have to go to conference if the Senate's not doing the same thing.
Mr. Chair, I just have a question again. Delegate Jackson's bill is a misdemeanor, right?
Yes.
Sorry.
Okay. Well, I will tell you, that my personal thought was that I would probably vote for a misdemeanor status on this one. And my thought was just because it's probably going to sweep in a bunch of kids doing prank calls, albeit dangerous prank calls that are of the type envisioned in the bill. And this was one of the points in the MSBA testimony that you're talking about creating employment challenges and things of that nature. The bill also originally had a higher penalty if the call actually led to someone getting injured. And I believe it's not structured that way.
That's correct.
In how the amendment is. So an injury is no longer required. I would also,
Mr. Chair, if I may,
Yep.
I would also ask that you guys actually use your legal minds to read it carefully, because I know it was crafted. This bill had been introduced in the Senate a couple of years in a row, and it was specifically crafted this year to try and make sure that we're not capturing those folks you just described, those kids, and that we're not capturing people who aren't deliberate in knowing exactly why they're making the call and exactly what they're trying to do. So that, if that is the reason to keep it a misdemeanor, then please read it carefully and see if it's already been addressed. Because we think that those folks are already not captured, and they wouldn't fall under this at all, right? But again, deferring to you all in your expertise and what we're trying to do overall in terms of criminal justice.
and sorry, can you remind us, has the Senate done anything on this bill yet?
Maybe council knows. I'd have to recheck, but when I checked yesterday, it was still in subcommittee, but I can recheck.
Nothing has passed the Senate floor. This has not come to the Senate floor. I don't know what they may have done or be doing in committee.
It doesn't look like it passed committee yet either. I looked it up.
All right, so we might have the first bite at it in any case. All right, any final thoughts?
Yeah.
Delegate Bartlett, go ahead.
I got one more thing. In line with what Delegate Hill was saying, just an FYI, on Delegate Jackson's bill, it starts as a misdemeanor, but if it relates into the death of someone, it goes to a felony. Just FYI. So isn't that kind of what you were saying, Delegate Hill?
I was saying that
they took that part out of the bill.
Right, that we actually we tried to make sure that the wording was such that folks doing it innocently, the teenagers, the kids, the college pranks, the pranksters do not get caught up. That this is for folks who are deliberately trying to get these folks to respond and maybe even be hoping for a bad outcome. So you'd have to look at how it's worded, but so it's a little bit different. Chair Moon is correct. We took out the part about it being more severe if it results in an actual injury or death, but we also thought that we took out the innocent pranksters from the bill the way it's been drafted.
Okay.
Delegate Eric Kane, is your hand still up to say something? No. All right, well, I'll tell you what. Are there lingering questions? I mean, I'd like to see maybe on this one if we can vote the amendments and vote the bill. Is there anyone that
Well,
feels like
are
we
you
need to hold
willing,
this?
Mr. Chair, are you willing to do a voice vote? I mean, a voice
Well, I want to talk about the,
on the DB?
let's just quickly get a sense on this. All right, Delegate Anderson, last thought.
Yeah, last thought. I know over the years, the fire marshals come in the past to deal with people calling in fake fire emergencies or pulling the firebox themselves to send the equipment out on the street, and that involves involves accidents. People have been killed for pulling false alarms. I was just wondering if there is a or what is the sentence, if we know right off the top of our heads, for a person pulling a false box or creating a false fire emergency, and is that sentence any different than if a person is injured or killed as a result of the fire emergency being done?
It's 9604 of criminal law, I think.
Wow, you got that off?
No. I just happened to have something open that had that there. I don't actually.
Got your Mark Pennack for a second.
Yeah.
Let me see. Alarm systems. Apologies. Give me 1 second. 9604. 5 years misdemeanor.
Okay.
Person may not knowingly make or cause to be made a false fire alarm or call for an ambulance or rescue squad. Misdemeanor up to 5 and 5,000.
And I think that was exactly the point of the folks on the commission, which is that it's not like it's illegal to do this stuff, but the misdemeanor is not sufficient, particularly the way things have been escalating to stop people from doing it. It's becoming a more and more popular thing. And the feeling was it's because we don't treat it like it's serious.
Well, with all due respect to Delegate Hill and the other folks, I think we do take it serious in the sense that it's a law that I just don't think it rises to the level of a felony of a crime like attempted murder or rape or things like that. And I think that the Bar Association, this is the Bar Association's amendment that we're going to take up with keeping it a misdemeanor, Mr. Chairman.
Correct.
Yeah, I would be in favor of that.
Okay, look, let's try and do this quickly. I was hoping we were going to be out of here with 15 minutes before committee, and we're going to bleed over. So look, if we stick with the misdemeanor, the bill still bumps the penalty up to 5 years, which would actually put it on par with trying to sick a fire truck on someone, right? If you think about pulling a fire alarm is sicking a fire truck on someone, and swatting is trying to sick the police on someone, this would up it. But let's go ahead and quickly vote the MSBA amendment. So maybe we need to do this one by voice. Well, actually, everyone's in front, everyone's visible. Let's do this
Mr. Chair,
by.
can I just have a comment period on this amendment?
Yeah, go ahead.
It's not a secret that this is just not going to get priority to be charged if we change it to a misdemeanor. It's just not. I mean, we know that it will not be. It will not. It just won't. So if we're and it's totally different than a fire truck. I mean, if you call a SWAT team on someone, it is almost like attempted murder. You are telling the police that someone is dangerous and is like a deadly person. That is as close to attempted murder as you can get without attempting murder yourself. You're sending in armed people with bad intel to someone's home. I mean, I just don't know how much closer we can get to the line of attempted murder besides that. So I'm really uncomfortable lowering the penalty. It's not going to get prosecuted the same way. The problem's not going to get solved. If the goal is stop people from using this tactic to threaten people, then I just don't know that a misdemeanor is going to do it, because the state, we can't say the state's attorneys, well, this is still a misdemeanor, but you should treat it like it's a felony. That's not how it's going to work. So then if the goal is fixing the problem, the felony fixes the problem. It says, this is a priority for the state of Maryland. You need to go after these people. They need to go to prison. End of story. Stop doing this. Because sending armed people to someone's house erroneously is crazy. It's crazy. And people will die, and they already have died from this. So, I mean, I'm very opposed to changing it to a misdemeanor, because it just won't get the kind of attention that I think it deserves. I am very supportive of Delegate Bartlett's DV amendment, though. I think we want to make sure that people who are victims of domestic violence are not somehow snagged in this, because they do sometimes call and they don't give accurate information because they can't, because they're in front of the person who's abusing them. So I want to make sure those people are protected, but I'm very opposed to changing this and downgrading it from a felony.
I would just add that, if you want to lower the penalties, that's fine, but I think that Delegate Arkin is exactly right. It's about, what's the state's attorney going to do with it? And do you consider this attempted murder? And if you do, then we should make sure our law says we treat it that way. And if you want to lower the penalties, I'd rather see that than to go back, but it's really your discretion.
Delegate Davis and then Bartlett. Again, let's try and
I know. I don't believe that it's our job to tell state's attorneys what to make their priority. All right. Different state's attorneys in different jurisdictions make different things their priority. Some of them don't handle DV cases at all, or don't make it their priority. In my county, DVs are a big deal. But I do not like the logic that we're supposed to criminalize people for longer because the state's attorneys aren't prosecuting. That doesn't jive with me.
Delegate Bartlett.
So I'm always in favor of lesser penalties, except when it is a result of a death. I'm more inclined to do an acceleration. So first time or whatever, no problem. It's a joke, hee hee ha ha, misdemeanor. But if it results in death, then I think we should be looking at it with the lens of a felony. I know it says, I know we're going to 5 years with the pulling of the, similar to the pulling of the fire alarm. And that, I get that logic, but since we are kind of noodling it around, I kind of like better if, that it's a graduated.
I mean, the only problem is we just took that amendment to get rid of the injury being a separate instance. So unfortunately,
that was the vote you're saying that's the vote we just did? That was the sponsor amendment that we just voted on? So we got rid of the
bill was introduced, had a separate tier if you were injured, but not as amended.
Oh, okay. Well, then I amend my vote. Then I prefer to have it as a separate tier, but okay, then fine. We'll keep, I'm fine with it then. It's harder. I kind of want to reiterate what Delia Davis was saying. I'm over here pulling out the code. I'm trying to follow along. I'm trying to figure out what's going on, but it's kind of hard if I can't see the amendment and kind of see what's going on here. So I amend my vote. I like the graduated much better. I don't like saying that if somebody dies and all this stuff happens, then all it is a misdemeanor. I like for it to be, if somebody dies, then it should be a felony.
Okay, so since everyone's visible on screen now, why don't we just do this by hand? So this is the we're voting in concept on the Msba amendment. If you like the amendment, which would keep this offense as a misdemeanor, raise your hand. If you want it to be a felony, do not raise your hand. So misdemeanor, raise your hand. Wait, did we just lose Fisher? Well, I have a feeling I know what's
Looks
about
like
to
it's
happen.
Yep, you got a tie.
Where's Fisher?
Maybe we should hold it.
Good Lord. Okay.
My hand down?
Yeah, you can put your hand down. Yeah, Fisher just got pulled, which means we, so now it's going to be a tie on that. Okay, well, I think this bill just got chucked onto our list with the other two bills for next time. So we have to resolve this issue of the felony misdemeanor, and we need Fisher for that, it seems. Let's.
Chair, is there anything that you need from me before the next one? Does any member need any additional information from me, from the police, from anything that I can give to help you to deal with? Again, it sounds like everyone's okay with the DV. Now it's back and forth about the sponsor, because sponsor amendment does stop the elevation component, and you're considering the bar's recommendation that it remain.
Well, I'll tell you what, it'll give you the opportunity to take another look at this question about the escalating situation if there's an injury, you know, as we sort the rest of it out.
Could I also add something?
Yeah.
Could you check then, Delegate Hill, if you're going to talk to the police, will they send a SWAT team based simply on a phone call from a citizen, or does the SWAT team come after there's an assessment by officers who are on the scene?
Okay.
In other words, can a phone call send the SWAT team out, or does it have to be done as a result of a
The
police
patrol
decision?
officer goes out, investigates, and the patrol officer says, I need a SWAT backup. Right.
Right.
That's what you're asking.
Or
I'm pretty sure. I'm pretty sure that happens. I'm pretty sure a police officer can ask for a SWAT team. But my question is, can a citizen calling into the 911 center create a SWAT team response without any police supervisor making a decision?
I think it can. I
We'll
think
check. I'll confirm one way or the other.
Well, I'm not asking for, I just want, Delegate Hill to, she said, is there anything else she can ask the police? That's one thing I would like to ask the police.
All right. Thank you all very much. Thank you, Mr. Chair.
Yeah. Delegate Fisher, are you yes or no on misdemeanor or felony?
Yes.
Which one?
Yes on misdemeanor.
Okay. And lastly, the domestic violence exclusion, is everybody fine with that one? Is anyone not okay with that? Okay.
So I'm clear, Mr. Chair, I'm sorry. So I'm clear. So if it goes back to a misdemeanor, you're asking, or you are still saying that it does that even if there's bodily harm, it's still a misdemeanor?
Well, I'm just putting a pin in all this now. You now are aware of where this subcommittee is on those dynamics. So you can just sort of take with you knowledge of where people are going to land on this. And if you want us to take another look at this as an escalating thing, we can do that. But let's just come back to this.
Very good. Thank you
next
both.
time.
Thank you all. Thank you.
All right. Thank you, everybody.